today. For your consideration, minutes were sent out, so I am looking for a motion to approve the minutes of February 7th, 9th, 10th, 14th, 15th, 16th, and 17th. So moved by Representative Patton, second by Representative Smith. All in favor? Oh, shush. All right, somebody's unmuted on the other end. If so, you could mute yourself on the other end, that would help us out as well. Okay, we have a motion and a second. Any discussion on the minutes? Seeing none, all in favor say aye.
Aye.
Opposed, no.
Aye.
All right, the ayes have it. Minutes are approved. We'll go ahead and open the hearing on House Bill 2705 and ask Natalie to give us an overview, please.
Thank you, Mr. Chairman. House Bill 2705 would remove the rebuttable presumption of an intent to distribute controlled substances and replace it with a permissive inference. The bill amends KSA 215705, that's the crime of distribution or possession with the intent to distribute a controlled substance. Current law there provides that in a prosecution for that crime, there's a rebuttable presumption of an intent to distribute if any person possesses a certain quantity of that controlled substance. So for marijuana, if you have 450 grams or more, for heroin, methamphetamine, if you have 3.5 grams or more, if you have 100 dosage units or more containing a controlled substance, or 100 grams or more for any other controlled substance, then in your prosecution, there would be a rebuttable presumption that your intent was to distribute those controlled substances. This bill would replace the words rebuttable presumption with a permissive inference. And then at the end of that paragraph, it would also require that there be facts to support that inference. And I can take any questions.
Can you help me understand the difference between permissive inference and rebuttable presumption?
I think that Tom Stanton is on, and this bill is actually in response to a court case that he handled, so I suspect he's going to get into what he thinks that meaningful difference will be.
Okay, sounds good. Committee, any other questions for Natalie? Representative Carmichael.
Thank you, Mr. Chairman. Without getting into Mr. Stanton's expertise, do you know, is there a case law in Kansas that defines permissible inference?
I am not sure, other than what is kind of talked about in this specific case. I'm not really sure outside of that. I'd have to do some more research into it.
I'm not asking you to do that. It's just I must have missed that class in law school, as I did many others, Mr. Chair.
All right, thank you very much. Any additional questions? Thank you, Natalie. All right, it looks like we have Reno County District Attorney Tom Stanton on WebEx for us. Tom, welcome to the committee.
Thank you for allowing me to appear by WebEx. This was about the only way I could do it. I appreciate the opportunity to testify today. I'll start just by explaining a little bit about why this bill is needed. We've had this rebuttable presumption ever since the legislature set up these limits or these presumptions clear back in 2012. They've been used. I've used them in many court cases. Lately, the Appellate Defender's Office has been challenging the constitutionality of that statute because of the term rebuttable presumption. For those of you who are not lawyers, obviously, when I go into court as a prosecutor to bring evidence in a case, the proof is on me, and it always is on me, and it never shifts to the defendant, and that's an important constitutional concept, that the burden is always on the state. The problem is just with the term rebuttable presumption, because if you think about what that means in your own minds, rebuttable suggests that the defendant must do something proactively to rebut that presumption, which means they would have to put on evidence or at least argument. There's at least that implication. I don't know that it's ever been required, but there's that implication. And the Supreme Court took up a case that I had. The case I had was State versus Holder. It's cited in my written materials. And to the question that came up earlier, as far as case law, this would be, I believe, the first case specifically addressing this particular issue. So there would be nothing prior to the Holder case. I do know that there were several other cases being argued about the same time. And the Public Defender's Office had brought up the same issue in each of those cases. In my case, I had a case with 40 pounds of marijuana. The presumption, as you just heard, for marijuana is 450 grams, which is about 1 pound. So I had 40 times more than that. The defendant never raised this issue below. There was no evidence at all presented at trial that it could have been anything but other than distribution. The only question was whether he was involved in the conspiracy. He was convicted. The Supreme Court upheld that conviction based on those factors I just mentioned, his failure to have standing, basically, and the fact that there was no evidence presented otherwise. But it became clear to me during oral arguments that the court did have an issue with the term rebuttable presumption, and there is a clear belief by several members of the court that term shifts the burden from the prosecution to the defense. If you were to read the Holder opinion, you would find that they talk about, in their opinion, the difference between a rebuttable presumption and the permissive inference. A permissive inference is not something that's required, and it's not something that the defendant is required to put on evidence to rebut. So it's not rebuttable. It's just a permissive inference that the jury can consider. The jury instruction for this particular portion of the law is actually written as a permissive instruction. It's not written as a rebuttable presumption. And so the jury instruction is accurate as to what we were trying to do, and that is just create for the jury this threshold in which, based on all the experience of the KBI and the prosecutors who worked on this bill originally, including myself, were accurate thresholds, and they remain accurate thresholds for that presumption. So what we're asking is, before the Supreme Court comes in and finds this to be unconstitutional moving forward, we would like to have it just go ahead and change it to a permissible inference. And then we doubled up on making sure that the defendant's rights were protected by adding the language that it was required that there would be evidence to support that presumption, which I think is also the best thing to do under the circumstances. So really, it's just a change in the law, that the wording of the law that reflects what the original intent of this legislature was in setting these presumptive levels, or these sales levels. And I'm asking you to approve and pass this bill. I would tell you that this has been vetted by the Kansas County and District Attorneys Association. They've reviewed my written testimony and the substance of the bill, and the Kansas County and District Attorneys Association is in favor of this legislation.
All right, very good. Thank you, Mr. Stanton. Committee, do we have questions for the district attorney? Start with Representative Howerton.
Thank you, Mr. Chair. I am not a lawyer, could you please break that down for me, the difference in the two meanings again?
So when I go into a courtroom in any kind of a jury trial, the state always has the burden of proof. And it's always been that way. That's the constitutional standard, because that's the system that we have in our country. When you talk about a rebuttable presumption, the thing that comes to mind when you hear that word rebuttable is that someone has to come in with evidence to rebut the presumption. In other words, the presumption stands unless the defendant comes in and does something affirmatively to overcome that presumption. When we do that, there's at least an implication that that's a shifting of that burden to the defendant. And that's why the term rebuttable presumption is problematic when it comes to constitutional review. A permissive inference is basically telling the jury that there is an inference that a person who possesses this amount or more of a controlled substance possesses it for redistribution, for sale. And this statute then, the way we have it worded is that we also have to provide evidence that it's for redistribution. We can't just come in and say, well, there's a presumption, you've got 3.6 grams of methamphetamine, that means you're selling. We also have to present evidence that would support that presumption. So in fact, we would do that in any case. It doesn't really change the way we prosecuted these cases. It just saves the cases from constitutional attack, because we would always bring in, let's say they had only 4 grams of methamphetamine. We wouldn't charge that as a distribution case unless we had packaging materials, O sheets, which are receipts showing people drugs have been fronted and money's going to be coming back, scales and other paraphernalia, other maybe cash, other indications, statements by parties, a previous controlled buy, those types of things that would support that charge of possession with intent. So we can't just walk in there and use this number and say, okay, anything 3.6 grams or over is for sale. We still have to present the evidence. So that's the difference in those two phrases. I hope that helped. Helped you.
That did, thank you.
Representative Patton?
Thank you, Mr. Chair. Mr. Stanton, I'm just now reading the opinion, so I don't have a whole lot of questions on that. I see the issue, though, but I do have one question. You said the Kansas County and District Attorneys Association supported this. They weigh in all the time over here with testimony. I'm curious why they didn't submit any testimony on this. Do you happen to know?
I do, because I personally am the person who authored the language for the bill, except for the changes to in the first sections. There were some stylistic changes. I didn't author those, but for this particular purpose, I did this. This was not something I vetted originally through the ks.gov. I'm a former president of that organization, and I have contacts there. This, up until 2 days ago, this case had not been set for hearing, or this bill had not been set for hearing. And so nothing had been done. The Attorney General's office had reviewed my request or the appellate division, because Natalie was involved in some of that, in observing some of those cases, Natalie Chalmers. So what I did was, when I found out that this was going to be for hearing, I sent the testimony, which I completed yesterday, to Steve Kearney at the ks.gov, and asked him to check with the board and see if they would review it and support it. He sent me a text this morning indicating that I had their permission to come in and advise this committee that they did support this legislation, and had reviewed my testimony and were in favor of it. So
Very good. Thank you.
Just timing issues.
Thanks.
Thank you. Representative Smith?
Thank you, Mr. Chair. My understanding then is that this really is not going to change how you do business when you go in and I'm going to give an example so maybe some of those who haven't been in the industry might understand. If I had 478 grams of marijuana that I took off of a defendant, that's a pound and about an ounce. So that would put him in that, under the statute, that with intent part. In other words, if you have that much, and to put that in usable practicality, a joint is about a gram. Now you may get one with 2 grams in it, but normally you're looking at then 400 to 450 joints that this individual would possess. You could assume that unless they're smoking 10 to 15 joints a day in a month, that 450. So this is the route you go down when you start to explain this in court to try and find a foundation. Is that correct? That
would be correct. We would put on evidence regarding the amount that of any drug that's used. For example, you used a really good example with anywhere from 0.3 to a gram of marijuana being in a joint, depending on the size of the joint. But let's say for purposes of methamphetamine, for example, 1/10 of a gram is a usable amount, is a normal user amount. But we would have to show that the jury that there were multiple possibilities, that you had scales or whatever. So yes, you had just the number doesn't convict the person. We would have to show other evidence that it was for distribution.
Right, and in this case, you're just changing the wording so that when you charge them, it's showing that you're not putting the onus on the defendant to come up with that rebuttal. We're showing that we're going to present the evidence that supports it, correct?
Exactly, the burden remains on the state.
Very good, thank you.
Thank you. Representative Osman.
Thank you, Mr. Chairman. I hesitate to say this because it's going to go to Representative Carmichael's head, but he makes a good point. As far as I'm aware, the KSA doesn't have permissive inference as a definition anywhere within the KSA. So I guess my question is, isn't that necessary? Because without that, you have judges that can define it however he or she wishes to within the courtroom. And how do you accurately explain it to a jury? I know you said that there's jury instructions, but how do you explain to a jury what permissive inference is without that definition available?
Well, if you go back and you look at Holder, that opinion itself looks at and talks about permissive inferences and what the definitions are out of case law. Normally what happens if we don't have a statutory definition, it's taken from case law, so it's not that it doesn't exist. When we put this together, I didn't consider trying to get a definition for permissive inference into the statute, but we don't necessarily have a specific definition for rebuttable presumption either.
Okay.
If you look at the jury instruction for that issue, it explains it really well. So I'm not as concerned with there not being a specific definition because I think it's found within the instruction.
Okay. I have no objection to the bill itself. I'm just trying to figure out if it would be beneficial to have that definition either within the bill itself to add into a definition somewhere within the KSA.
We can certainly work on trying to provide that to the committee if that's what you would like.
Okay, thank you.
Thank you, Representative. I know I was just asking Natalie, and he kind of answered the question, and that is there's no definition of rebuttable presumption either that exists in statute. So it's just based on, court opinion, right? Yeah, that's what I was under the impression of. All right, additional questions for the district attorney. Representative Carmichael.
Thank you, Mr. Chairman. I was having a sidebar conversation, Mr. Stanton, with my colleague, the distinguished representative and barrister from Garden City, former prosecutor you probably know, and past president of your association.
I know John very well, or Representative Wheeler.
And we won't belabor this, but he's also what's known as a double lot. And if you don't know what a double lot is, you'll have to ask some other place. That all being said, though, like Chairman Patton, the distinguished barrister from Garden City, and I were both trying to read the opinion very quickly because this truly is an issue of first impression to me because I didn't know anything about it till I sat down here today. But in reading the Court of Appeals opinion, as well as the per curiam opinion of our Supreme Court, it appears that the conviction was affirmed by the Supreme Court. Do I understand that procedurally to be correct?
That is correct.
As I listened to your testimony, though, I gained the impression that the concern was that the issue was not raised below as to whether or not this rebuttable presumption created a constitutionally impermissible shifting of the burden of proof to prove each and every element of the crime by beyond a reasonable doubt. But I got the impression that you were telling us the reason the court didn't reach it is it wasn't raised below. But as I look at the per curiam decision that my colleague found, they actually, I think, affirmed, the Supremes did, on the basis this was harmless error, because the instruction given at the trial was in fact an accurate statement of the law and was not in and of itself a constitutionally impermissible shifting of the burden. But you tried the case, you know it better than I. Can you help us with what seems to be an inconsistency? Was the affirmance based upon the harmless error doctrine because the instruction given was in fact consistent with the law, or was it a failure of the defendant to raise the issue at trial?
I believe it was a failure of the defendant to raise the issue. The instruction itself did not suggest a shifting of the burden. The problem that the court had when I was arguing it was that the language of the statute and the language of the instruction are somewhat at odds. And there is a body of law that says that instruction must reflect the statutory language. And so while the instruction was basically a permissible inference instruction, I got hammered pretty good on the question of whether or not it accurately reflected the law as it stood. And that's why I came in with this amendment, because it is my opinion. I've been doing this for more than 30 years. I've been a drug prosecutor for most of that time. I've been the DA now here for about a year and a half. But I've been before the appellate courts and the Supreme Court a number of times. I've been there when they didn't have very many questions for me, and I've been there when they hammered me pretty good. In this particular case, they were hammering me pretty hard on that the issue of whether or not the instruction corresponded to the law. And if the instruction didn't correspond to the law, and one of the arguments that was being made by defense was it didn't matter if the instruction was good and that the instruction itself didn't shift the burden. If it doesn't reflect the actual statute, then it is an improper instruction, and therefore we have to go back and look at the statute. And if the statute's unconstitutional, then the application of the inference is unconstitutional. So the reason I brought this is because I am convinced, based on my experience with the court, and even in my discussions with Natalie Chalmers afterwards, that it is only a matter of time before the court has a case before it in which it was raised below, and we have a closer call. It's not much. It's not hard for the court to find harmless error in my case, because I had a 40-pound case, and the presumption is 425 grams, and so there was no way a jury is ever going to find that was for personal use. That was my understanding. That was the harmless error issue or ruling of the court, was that under any circumstances it was harmless error because there was no way a jury was ever going to come to a different conclusion than what they did. That leaves, though, the problem, and I'm looking at the decision now, and if you give me just 1 second, I'm trying to determine where in here I read about the court finding that the defendant. So on page 9 of the opinion, when they talk about the definitions of rebuttable presumption and permissive presumption, the opinion says these definitions tell us Holder has a point when he complains about the apparent discrepancy between the permissive inference instruction given in this case and KSA 2020 supplement 5705E1's rebuttable presumption. So in that opinion, they're saying he has a point here. But they go on to say later on in the opinion that starting on page 11, talking about clear error standard to the question of harm because of the instructional error claim was not properly preserved in the district court. And so they use several different methods to get to the point of saying, you know, we're going to affirm this conviction, but they sent as many red flags as they possibly could to let us know as prosecutors that this language had to be changed, or in a different case where it is brought up and the amounts are closer together, we're going to have a problem with the fact that the instruction does not reflect the language of the statute.
And Mr. Chairman and Mr. Stanton, I must confess that as I read the decision in more detail rapidly, I would have to agree that the harmless error doctrine may not have been directly applied to the question that was probably never reached because of a lack of standing on account of not having raised the issue below. So I think I'm leaning more toward what Mr. Stanton is saying. But I am reluctant, Mr. Chairman, to make this type of wholesale important change without hearing from our Attorney General and without, frankly, hearing from the defense bar as well. If this is the pressing matter of appellate law, I would certainly want to give the Attorney General and his experts an opportunity to chime in. Mr. Stanton's a fine prosecutor of excellent reputation. I don't mean to say otherwise, but I'm concerned about moving forward based on the testimony of one county attorney, deputy county attorney, or district attorney.
Understand, they were given, I think we sent this out about 48 hours in advance. So my presumption is they would have been watching and would have chimed in given if they wanted to, but I understand your concern.
Just haste makes waste, Mr. Chair. Thank you.
That's right.
Is that a rebuttable presumption, Mr. Chair?
Yeah. No, definitely permissive inference as I understand it. Any additional questions for the district attorney? All right, seeing none, thank you very much, Mr. District Attorney Stanton. Appreciate you being here today. He is the only proponent that I have listed on this bill. Were there any other proponents, neutrals, or opponents? All right, seeing none, we'll go ahead and close the hearing on House Bill 2705. We will not be meeting tomorrow, but we'll be back here on Monday for a full week of hearings and bills. And so with that, enjoy your weekend, and we'll be adjourned.